Students for Fair Admissions versus the President and Fellows of Harvard College.
This case is related to the Equal Protection Clause of the 14th Amendment. The Equal Protection Clause prohibits states from denying any person within their jurisdiction equal protection of the laws. In the context of affirmative action in university admissions, the constitutional question often revolves around whether a university's use of race as a factor in admissions decisions violates the Equal Protection Clause. The Students for Fair Admissions, or otherwise known as SFFA, v. Harvard case in particular addresses the question, may institutions of higher education use race as a factor in admissions? If so, does Harvard College's race-conscious admissions process violate Title VI of the Civil Rights Act of 1964?
The case of Students for Fair Admissions v. Presidents and Fellows of Harvard College, commonly referred to as the Harvard Affirmative Action case, is a lawsuit filed by the organization Students for Fair Admissions against Harvard. SFFA, led by Edward Blum, is an advocacy group that opposes affirmative action in college admissions. The case gained significant attention and became a focal point in the ongoing national debate over affirmative action in college admissions. Advocates for affirmative action argue that it promotes diversity, helps address historical inequalities, and benefits underrepresented minority groups. Critics contend that it amounts to reverse discrimination and violates the principles of equal treatment and meritocracy. With schools becoming more and more competitive nowadays, universities are faced with the problem of balancing a diverse admissions process while also admitting students with strong qualifications. As a result, many colleges use a holistic admissions process that is currently under scrutiny.
Students for Fair Admissions argue that Harvard's admissions program violated Title VI of the Civil Rights Act of 1964 by using race as a determinative factor and imposing a de facto quota on Asian American applicants. It's important to note that although Harvard is a private university, it receives federal funding, making it subject to Title VI of the Civil Rights Act. Students for Fair Admissions also argued that the court should abandon the framework established in Greta v. Bollinger and prohibit any consideration of race in admissions, as it is not narrowly tailored or necessary to achieve diversity. On the other hand, Harvard College argued that its admissions program complied with the court's precedent and considered race as one factor among many in a holistic and individualized review of each applicant. Harvard also argued that there were no workable race-neutral alternatives that would achieve the educational benefits of diversity. They also argued that the court should reaffirm its prior decisions that supported universities in their goal of achieving a diverse student body.
After a 15-day bench trial, the district court issued a detailed opinion in favor of Harvard. Students for Fair Admissions appealed, and the U.S. Court of Appeals for the First Circuit affirmed the decision, siding with Harvard. Students for Fair Admissions then appealed to the Supreme Court.
There are a number of related cases, including the 1978 case of Regents of the University of California v. Beck. This case established the constitutionality of affirmative action programs and allowed universities to consider race as one factor among many in admissions. However, they could not use it as a quota system. Another case is Gratz v. Bollinger and Grutter v. Bollinger. These cases upheld the use of race as one factor among many in a holistic admissions process, but struck down a points-based system that automatically awarded points to underrepresented minorities.
The most recent cases regarding affirmative action are Fisher v. the University of Texas at Austin in 2013 and 2016. These cases reaffirm the principle that universities have a compelling interest in achieving the educational benefits of diversity and consider race as one factor among many in admissions, but also require them to demonstrate that their policies are narrowly tailored and that no race-neutral alternatives would achieve the same goals. These cases are relevant to Students for Fair Admissions v. Harvard because they set the legal framework and standards for evaluating race-conscious admissions policies. It is hard to predict with certainty how the court will decide the case, but based on the oral arguments and the composition of the court, it seems more likely that the court will rule in favor of SFFA and against Harvard. Some possible reasons are that the conservative majority of the court has expressed doubts about the constitutionality and necessity of affirmative action in previous cases and may be inclined to overturn or limit Grutter v. Bollinger and its predecessors. Also, the justices asked more challenging questions to Harvard's lawyers than to SFFA's lawyers and seemed more persuaded by SFFA's arguments that Harvard's use of race was not narrowly tailored or transparent. The justices also did not seem convinced by Harvard's evidence that there were no workable race-neutral alternatives that would achieve the same level of diversity, and suggested that Harvard could use other factors such as socioeconomic status or geography instead of race. Of course, these are only possible indicators and not conclusive evidence of how the court will rule. Here is a clip showing the Chief Justice John Roberts questioning Harvard's lawyer Mr. Waxman about Harvard's admissions policies regarding race.
Take two African American applicants in the same category, however you want to take it. They both get, or both can get, a tip, right? Based on their race. And yet they may have entirely different views. Some of their views may contribute to diversity from the perspective of Asians or whites. Some of them may not. And yet it's true that they're eligible for the same increase in their opportunities for admission based solely on their skin color.
So the point—
That was a question.
No, I know. I'm attempting to answer your question. There is no doubt that as the testimony showed, that for applicants who are essentially so strong on multiple dimensions, so extraordinarily strong on multiple dimensions, that they are sort of on the bubble, that they're a real candidate for admission, being African American, or being Hispanic, or in some instances being Asian American, can provide one of many, many tips that will put you in.
People say that, yes, but you will have to concede that if it provides one of— Take two—
Banning affirmative action in college admissions could have significant implications for higher education and society as a whole. A decision banning affirmative action would force elite colleges to revamp their policies and search for new ways to ensure diversity. Beyond just the admission to the school, this ruling will strike down educational equity. Less diversity in education will directly correlate to less diversity in the professional world. Therefore, outlawing the consideration of race in college admissions would only further cement racial inequality and segregation in our country. While there will likely be a decision in favor of the Students for Fair Admissions banning affirmative action in some way, the result is still pending and could swing either way. We expect a final decision from the Supreme Court in June of this year.